mean, the reason sponsors go out to get investors is because they either don't have the money or they don't have all the money, and they want to do not just one deal, they want to do 3 deals, right? They want to do 4 deals. So they go out and get investors.
So you want to be a real estate investor, but where do you start? How do you know what information and sources to trust? That's where I come in. I'm Jonny Catani, and this is the Investor Relations Real Estate Podcast. Hey guys, real quick, before we start, go to investwithcatani.com and download my free ebook, Is Commercial Real Estate Recession Proof? Now to today's show. What's up, guys, and welcome to another episode of the Investor Relations Real Estate Podcast. I'm your host, Jonny Catani, and I am joined today by Trevor Crow. Trevor has represented an array of companies, founders, and investors for the past 10 years. His focus is business transactions, including complex joint ventures and real estate syndications. Trevor has extensive experience representing sponsors and investors in syndicated real estate deals, including negotiating and drafting securities offering documents, LLC agreements, and ancillary documents used in real estate syndications. Trevor, welcome to the show.
Hey, thanks. Thanks for having me.
Absolutely. Looking forward to today's conversation. I know that this is the stuff that can get complex, right? So we're very grateful as investors that you guys are available to us and, know the ins and outs. But before we kind of get into the weeds here, give us just kind of a backstory, what caught your attention about this area and where you're at now.
Yeah, so I kind of backed into this area a little bit, not necessarily on purpose. I came out of law school in 2009, which was a bad year for real estate and for graduating law school, it turns out. Bad year for the whole economy. And so the work that was out there there wasn't a lot of business transactional work. There was litigation going on. Firms weren't hiring. So I was kind of trying to figure out where to go. The firm that I was supposed to go to kind of said, we don't have a spot for you anymore. And one of my professors at DU Law School where I went to talk to him and ask him if he could introduce me to somebody. And he said, no, don't, I can introduce you to a couple of people, but nobody's hiring right now. Don't even try. But what you should do is come do this tax LLM program instead. And so anyway, long story short, he ended up giving me a scholarship to do that. But through that program, I met another guy who was a well-known tax attorney in town at a real estate shop in Denver. And so anyway, I didn't go work there right after I finished law school. I went to a couple other firms, bounced around. I was doing business transactional work, but they ended up losing somebody. And I met that professor through the program, and he called me and said, hey, we lost somebody and we need somebody to come fill a spot here doing corporate transactional work. You can continue your practice, but also support our real estate group, which we have a large real estate group doing development deals and things like that. And so anyway, ended up going to that firm in 2014. And that was, like I said, it was kind of called Otten Johnson's, well-known real estate firm in Denver. And so I did all the corporate work. We represented developers, and I was doing the operating agreements. I was doing all the securities work, subscription agreements, things like that, PPMs. And so I kind of fell into it that way, and was a partner there for a year, and then decided to go out on my own and start my own firm. And honestly, I was worried that because I didn't do all the entitlement work, I didn't do the real estate purchase agreement work, that I thought I might lose all my kind of real estate clients because I didn't have the real estate attorney support. But I went out on my own, and it turned out there was still a need for just doing the operating agreements and the corporate work for the real estate clients. And so I kept many of them, and that's kind of been a large part of my client base now, is those real estate developers who need the corporate work. And so, I had my own firm, then I merged my firm with another guy who had a very similar practice. And now that's where we're at with Doida Crow Legal, which came together in 2021. So last year.
Awesome. I love it. Yeah, that is kind of a back way in. But, obviously has worked out well for you. So you mentioned developers. Kind of talk about what goes into those as maybe opposed to another syndication or joint venture that, is different.
Yeah. So with the development deals, it's a different type of investor, somebody who's willing to take that construction risk, basically, or development risk and entitlement risk. And so those deals are usually set up differently. But I love dealing with developers because they're those people who are driving down the road and see an empty field or a rundown area and think, oh, what could that be? How could I make that better, type thing. And so with the development deals, you got to have the investors that are willing to take that risk. A lot of times you don't close on the property until you have all the entitlements that you need. So if you're saying, hey, I got to empty, if I have raw land here and I want to build an apartment building, you want to make sure that you can actually build that apartment building. So, you'll have a purchase and sale agreement that has a long inspection period, due diligence period, and things like that. And during that period, you'll get the entitlements that you need. So, when you close on that real estate, you're shovel ready. And so that's the type of, a lot of times that's how it works, right? Where developers going to say, hey, this is what we're going to do. And they're shovel ready. And so then the investors aren't taking the entitlement risk, but they are still taking the risk with construction and things like that. Oftentimes we do kind of as a two-tier step. So, if you're doing a value add deal, so it's kind of switching for a second. If you say, hey, we're going to buy this existing apartment building, we're going to fix it up, we're going to add some amenities, we're going to increase rent, and we're going to, get it up to capacity and then flip this thing, right? So we're just going to kind of do that work. There's certain investors that are willing to do that, and they understand it and they invest, right? And that's a pretty simple, like, one syndicated deal. Alternatively, if it's a development deal, a lot of times what I see is we have the initial investors who will invest to get kind of through the construction period, and then they go to some more to get more investors after that, for example, or they get initial investors to do the entitlement piece of it, and then they'll get kind of the vertical investors after that. And so we might have to set up multiple LLCs, and then the offerings may be different for each one. The investors who taking the larger risk investing in the earlier part are going to get a bigger chunk of the deal moving forward. So yeah, I mean, it definitely differs in both the investors and how we kind of structure the deal, I would say.
Yeah, it makes perfect sense. I know it's pretty common to, like you said, sort of two tiers, one tier to help purchase the land typically, and then maybe after the land is purchased and you go to a construction loan, sometimes you get those investors out. Mm-hmm. So that would obviously be, its own documents. And then you have your next tranche, which is your, investors who are going to be there through the construction and into stabilization and all of that, of whichever asset it is. Obviously apartments being the most common. So, as we go through that, obviously each document has its purpose. What does it look like setting those up? Is it kind of a plug and play when it comes to a lot of language, or does it, have to be pretty close to custom for each deal?
Yeah, there is definitely a portion of it that's going to stay the same in all agreements. And so, these agreements can vary from 20 pages to 60 pages in length, depending on who you're dealing with and how many investors are involved and what type of investors are involved. If you have one big capital partner who's coming in, they're represented by big firms, and usually that's when you get the 60-page agreement that you're going over. But as far as there's a lot of pieces that are negotiated, right? So there's obviously how the economics work. So how does that distribution waterfall work? A lot of times that's determined by the business people prior to coming to me, either in an LOI or a term sheet or just, hey, this is the deal. And so we can kind of insert that in there, but those can vary, whether it's hey, we're going to get it's going to be an 8% pref return of capital and then an 80-20 split, for example, or it's going to say, hey, we're going to do a 10% IRR, and then then there's a catch up to the sponsor, and then there's a 80-20 split, and then we hit another IRR hurdle and it goes to 70-30, you could get as complicated as you want on the economics. So that piece changes a lot in the operating agreement. The other pieces that change are, are there going to be guarantors of the loan, and what sort of rights do the guarantors have? Is there guarantor indemnities? Is there rights to sell the property if that guarantee gets called? So those get negotiated and put into the agreement. Removal of the sponsor, that's a huge one that gets negotiated. So typically the sponsor has management control, but then what if something happens? They commit fraud. The easy ones are fraud, gross negligence, willful misconduct, things like that. Yeah, it's hard to argue that you shouldn't be removed for that. But then it gets into a bunch of other things like, what else could be in there for you if you don't hit certain returns or things like that? Can you be removed? If there's just a number of things that could be added in there and negotiated to remove somebody. And then what happens if the sponsor is removed, right? So do they lose their promote? Do they lose, is that totally lost, or is that something that's considered earned at the time that the deal is struck? All those things are negotiated. But really it's the management and control piece, right? So it's management, control, and economics. Those are the kind of the three areas. And what are the major decisions that those investors have? So that also gets negotiated too. So, here's the things that the manager or sponsor can't do without getting certain investor approval or a certain threshold approval. So that's also a negotiated piece. And then the amount of negotiation is going to depend on who your investors are, right? If it's dispersed amongst a lot of friends and family, high net worth individuals, but nobody's putting in such a huge chunk, then I feel like there's less negotiation going on because there's less leverage by any individual investor. As soon as you have the large capital partner, it's nice because you have just one person on your cap table, or maybe just two, but they're going to really be able to control a lot of the terms at that point.
Yeah, absolutely. Those institutional investors, family offices on up, will, like you said, no surprise, there's 40 extra pages added because they certainly do have a lot of stipulations that come with, their check writing. So pros and cons, right? Some operators are more than happy to do it. Others just stick to the retail investors, and just have a lot of them for some of the larger deals. So you mentioned, kind of the three main areas there. What does it look like when a deal does go wrong in terms of, kind of triggering some of those things and having to either remove a sponsor or take it to some kind of mitigation or litigation?
Yeah. I mean, it's messy. No matter how the documents are set up, it's messy because a lot of times it's something that's not cut and dried. And, you can't have it, even something like fraud, for example, seems like, oh, that should be easy to spot. And sometimes it is, sometimes it's not, is it actually, is it just, if somebody's stealing, somebody was stealing chips from the vending machine at the bottom of the building, is that fraud? I mean, technically, probably yes. But is it a material fraud? No. And so, I mean, that's kind of an extreme and strange example, but that's just one of those things that's come up. The other thing that I've seen, and it has come up one time with where the sponsors are running businesses a lot of times that they want to do. I mean, the reason sponsors go out to get investors is because they either don't have the money or they don't have all the money, and they want to do not just one deal, they want to do 3 deals, right? They want to do 4 deals. So they go out and get investors to be a part of this, but then they're running businesses themselves where they have accounting departments, they have staff, they have things like that. So, we had a situation where a client, unfortunately, had a controller that was stealing money. The main sponsors had no knowledge of this. They weren't involved in it. This person was stealing money, and it was technically fraud. And it was something that they could all be removed, and they could lose their whole promote and their interest in this deal. luckily it worked out with the investors. They were able to, fire this person, sue this person. And luckily they had the insurance, I forget the name of it, but the type of insurance that covers that sort of theft insurance that covers that sort of thing. And so they were able to recover some of it, return it to the entity, and the investors, chose not to remove them. And so that you can see things like that happen. Other times you can see where internal disputes among sponsors, I think, is also a big issue. Two people or three people are sponsors and they want to do this deal, but maybe some of them feel like they're doing more than the others. And so that's always a tough thing to handle, especially in the different agreements. So sometimes what we do, at least, is, if you have the syndicated real estate LLC that owns the property, has the investors in it, we might have a separate entity that's the management entity. So if there's three sponsors, they can deal with their sort of issues in that LLC agreement rather than trying to mix it in with these other investors here. So, if somebody's not pulling their weight, they could maybe be removed from that entity or something like that. So oftentimes that's what I see more than anything is fights among sponsors. And sometimes that can be helped with an LLC, a separate manager entity LLC. What else? With that, I guess depends on your investors, but that other, the joint venture LLC with the investors in it may have some sort of key person provision in there that there's, one or two of those people, or at least, one of the sponsors has to be around. If there was three, for example, and they wanted to get rid of one, then you have, two of the three remaining. And so there's, that person, they don't automatically lose their promote or anything like that. If there's a situation where one of them has to be removed. So yeah, I'm trying to think, those are the, where I see disputes, disputes about, there's also disputes about capital calls sometimes, disputes about whether you've taken an action that's either a major decision or not, with or without the correct approval. I feel like that's where people kind of run into issues because, we draft these operating agreements and then a lot of times they get signed and then put in a drawer and not looked at again. and so in the rush of the day to day, people may be doing things that actually required consent, but they're just not thinking about it. And so I think that's where people get in trouble, and where I would, point that out as something that you're dealing in this world. You got to remember, what your duties are under that operating agreement.
Yeah, absolutely. Right. I mean, so many times I think you're right. You just sign the operating agreement, PPM, and, you're just DocuSign and you're on your way.
Right.
But kind of putting on our passive investor hat, we've got a lot of passive investors who listen to this show. What are some keys when we are looking over those documents? Let's say we're, joining an operator. It'll be the first time we've invested in their deal. We vetted them. They pass everything we want, but, of course, we want to make sure the documents work out. What are some keys there when looking through those, so we don't, get our heads spinning around from legal jargon and can actually understand, what my rights are compared to theirs, and, how much power you have or don't have.
Mm-hmm. Yeah. So, and I, as where I'm thinking back to all the things that I've said, we represent a lot of the developers. So we're usually coming from that side as opposed to the investor side. But from the investor side, I think the keys to look at, one, you want to look at the fees. So, we have the economics we've talked about with the distributions and how that flows out. But what where the leakage sometimes happens is in all the fees that might be involved. So sometimes there's a management fee, sometimes there's an acquisition fee, sometimes there's a disposition fee, there's a refinance fee, there's a guarantee fee. These fees can just pile up. And so that's one thing to look at when you're looking at an operating agreement, not just what are the economics that you get in the distribution waterfall. So, not just hey, I'm getting a 10% IRR, and then it's an 80-20 split. It's okay, that's great, but what are all the fees going out as well? So that's one thing to look at. The other thing from a leverage standpoint, I think biggest hammer that the passive investors can have to help kind of make sure they're keeping people in line, in my mind, is one, there's a budget that gets approved by the members. Not just a manager proposed budget that's self-approved. It gets approved by the members, some threshold of the members, right? And that there's removal rights, removal and loss of promote rights. So if that kind of keeps people in line, because that's what they're doing this for, right? At the end of the day, that's where the big payday for the sponsors and the managers of this is to get that promote. And so if they have some provisions in there that will will cause them to be removed and potentially lose their promote, that helps keep people in line, I think. And then the major decision rights, right? Those are all the protections that you have in there. Whether or not, you may be a passive investor and not have control yourself, but at least you know that the other people who are investors and sitting in your same sort of seat that are passive, collectively, you as a group have control over approving that by some majority percentage, right? And so those are the big things, like maybe selling the property, maybe incurring debt, maybe anything like that. Those big decisions, threshold decisions over a certain amount, or expenditures over a certain amount, exceeding the budget, capital calls, things like that. Those are where I think passive investors can really get protection under agreement, and what you should look for.
Awesome. Yeah, I appreciate that insight. Obviously, very important to understand that. As the check amounts. A $50,000 minimum is not a small fee, right? So,
yeah.
And that can be a lot of money to people, especially in their first deal. So it's important to understand what you're getting into. What about having someone a lawyer look over it for you as well? Is that, something that you've heard of people having, passive investors primarily having done?
Yeah. So I would say it happens less often. A lot of times I get a lot fewer calls from investors saying, "Hey, I'm putting $50,000 in this deal. Can you review this operating agreement?" It's more the sponsors that are saying, "Hey, we got to raise $2 million or $3 million. Can you help put together the documents and the subscription agreement, PPM, and things like that for it?" But I don't think I think two things from the passive investor side is, one, if you don't understand it, then I think it does make sense to reach out to an attorney, because they can help you do it even from a high level, to say, "Hey, here's what I see is the big items as potential red flags." But when I have had those calls, I've always had to give the caveat that, hey, whatever red flags I raise, you're going to probably have to make a decision whether just to invest or not. You're probably not going to have the negotiation leverage if you're investing a small amount. If you're investing a lot, then it makes more sense to have representation and actually negotiate that agreement. And that's what all the big capital partners do. They have their own attorneys, and they negotiate those very heavily. But the other thing that which happens both in the startup world and in the real estate world, I think, is sometimes you do have some sophisticated investor who's writing a bigger check, and that can give you comfort that me as an investor, if I'm coming in the same class and getting the same membership interest that this person's getting, that they've done their due diligence. So that, like I said, in the startup world, it happens when a big VC firm writes a check to invest in a company, then a bunch of angel investors say, "All right, hey, I'll pitch in too." And they don't do any due diligence, because they just are riding the coattails of whatever that VC firm is, knowing that they probably did the due diligence. The same thing I've seen in the real estate world, where somebody comes in and writes a bigger check that's sophisticated and does these sort of things, then a lot of angel investors can come in and say, "Oh yeah, okay, I'm interested in this as well, and I'm just going to rely kind of on what they've been doing." So I think that's another way that you might get comfort with what's going on in the operating agreement.
Yeah, absolutely. That's a really, really great point. And why, same thing, right, with referrals, kind of mitigate some of that stuff up front if someone you trust has invested with them, or like you said, a large institution coming in, you know, you would hope that they've done, you know, extensive due diligence when they're writing a big check. So awesome. I love it. Well, this has been great. I really, really appreciate all of the insight. I know the listeners do as well. We'll jump to the final 5 here. First question, best advice you've gotten from a mentor?
Best advice is that to be clear on what you want, and then work as hard as you can and for as long as it takes to get that.
I love it. What is it about your career that makes you feel like you're fulfilling your why?
Well, I love working with entrepreneurs, honestly. That's I feel like my why out there is working with businesses and entrepreneurs. And, you know, we represent entrepreneurs in a lot of different capacities, whether it's startup companies or if it's real estate sponsors, if it's, you know, I consider investors, entrepreneurs, people who are dealing in business, who are making things happen, deal makers, investors, fund managers, those type of people. We love dealing with them. And that's kind of, if I wasn't practicing law, I'd probably be serving, you know, entrepreneurs in some other fashion. So that's my why.
I love it. Yeah. We're obviously biased, but I completely agree. I like working with entrepreneurs and people who sort of, I guess we all think a little bit differently. I don't know what it is, but you know, it makes it more exciting for sure. Favorite non-real estate or investment related book?
Non-real estate or investment related book. Gosh. Let me see here. I'm going to have to pull up my Audible because
I love it. I'm
so bad at remembering books names, but non-real estate or investment.
I know. Well, like, do you read any like self-help or? Gosh, I don't remember the last time I read fiction, but I know people still read fiction.
Yeah, no, I haven't. Well, you know what I think is a good one is Deep Work by Cal Newport. That's not investment or real estate, and that has been a big one, I think, for me. That is just, you know, that's when you get actual big things done on your business is when you can take the time to focus and have to allocate that time. Now, I'm not very good at following that advice always, but it's been something that's been in the back of my mind. I think it's a good read, so I'd suggest that one.
Awesome, love it. If you could have any superpower, what would it be?
Oh man, superpower. It would be to, you know, part of me wants to fly, but I would say being able to breathe underwater.
Nice.
It'd be fun to go around and search the ocean.
I couldn't agree more. Mine probably top one is flying, but yeah, second would be underwater for sure. Two favorite places. Cool. What's the best way for people to get a hold of you and learn more? Yeah,
you can email me is probably the best. It's Trevor@doidacrow.com. And so that's DOIDACROW.com. That's the best way to catch me, Trevor@doidacrow.com. Or you can, check out our website. There's ways to connect with us there.
Cool. We will link that in the show notes. Trevor, thank you so much for your time and all of your insight.
Thank you. Appreciate it. That was fun.
Absolutely. Hey guys, thank you so much for watching today's episode. I hope you really enjoyed it. Listen, I know it's cliche and you hear it all the time, but please don't forget to like and subscribe to the channel so you know when the next video is coming out. Even though this is technically a daily podcast, you know it's coming out the next day. We have a ton of content coming your way. So please like and subscribe. It helps a ton. Leave comments. Would love to know what you guys think. And we will see you on the next one. Thanks so much.